How important is your legal representation? Hi, I'm Simon Dippenaar and I'm an attorney. All lawyers are trained in the same way, so any lawyer can represent your case, right? Well, not exactly. A case came before the Gauteng High Court recently that demonstrates the importance of rigorous preparation for an eviction matter. This was an appeal against an earlier judgment, and the entire case is chaos from start to finish. The original case was an eviction order of a tenant who had occupied a property for years. The applicant, the owner, claimed the premises was occupied without consent, and therefore the occupier was in unlawful occupation. The occupier had also wrongfully erected structures on the said earth without consent. Magistrates in the case granted the eviction order because the defendant had failed to discharge the onus by not placing sufficient and relevant circumstances on record, unquote. The appeal was brought because the occupier believed the magistrate had made a mistake in the application of PI, the Prevention of Illegal Eviction Act. The appeal was upheld because the onus is not on the defendant, but on the applicant to place sufficient information on record. The eviction order was overturned, but what is of interest to us in this case is the reasoning behind the judgments. In the first instance, the magistrate was provided with inadequate particulars in the founding affidavits. Critical details were absent. Essential facts like dates, proof of consent to occupy the property and build a dwelling, or not, proof that the property had been purchased by the occupier or not, etc. The magistrate should have dismissed the eviction application in the absence of proof that an eviction would be just and equitable, or, based on the limited evidence, the magistrate could have ordered the parties to deliver more affidavits, properly addressing the material facts, or he could have referred the matter to trial. There is a precedent in case law. Quote, in brief, where no information is available or where only inadequate information is available, the court must decline to make an eviction order. The absence of information is an irrefutable confirmation of the fact that the court is not in a position to exercise the important jurisdiction, unquote. Because of the magistrate's error, the appeal was legitimate. However, once again, due process was mocked by disregard for proper procedure. The appeal judge said the appellant approached the matter with a lackadaisical approach to the obligations to prosecute an appeal. The appeal was noted late, security for costs was given late, the appeal record was in a state of disarray. What is glaringly missing is a statement by the appellant's attorney that makes accountability for the defective work, unquote. The eviction order was set aside because it lacked merit despite the poor quality of the case presentation, but instead of recovering all costs, as would usually happen, the judge ordered the appellant to recover only 40% of the costs because there were so many wasted costs caused by the appellant not properly prosecuting the appeal. In legal terms, this was a disgrace, but both the original application for the eviction order and the appeal were procedural shambles. Material facts were missing from the affidavits, evidence was scanty or lacking altogether. There was almost contempt for our justice system and the authority of the courts in the tardiness of actions and the substandard quality of the documents submitted. At ST Law, we pride ourselves on meticulous research and preparation of your case. Before we go to court, we make sure every T is crossed and every I dotted. We will gather and collate all your evidence until your case is watertight, both procedurally and evidentially. Don't settle for less than the best. Give me a call on 086 099 5146 to discuss your legal matter.